This is Michael Clara, coming to you from Salt Lake City, Utah, with update number 15 to the Spencer Cox signature list cover-up. The subtitle to this update is The Plot Against Utah's Gubernatorial Candidate, Phil Lyman. That is not hyperbole. I hope that over the past year, I've shown that there is a seemingly coordinated cover-up where the truth seems to always remain hidden or even blocked from dissemination. In isolation, every little event can be explained away or dismissed as incompetence by those in government. But taken together, a picture emerges of a coordinated, ideologically rigid group of elected and appointed officials who manipulate the levers of politics and justice for their own ends. A whistleblower has come forward with a copy of case number AG24-170, a report that the Utah Attorney General's office claimed did not exist. And for lack of a better term, I'm going to refer to it as the offense report. So here's a timeline for the 2024 campaign cycle. And as you recall, it was the Cox-Henderson campaign that took the signature path to get on the primary ballot. And then it was Lyman and Clausen that took the convention path. So the signatures were turned in starting in February by the Cox-Henderson campaign, and then they had completed that process by March 15th. And then we had the Utah GOP nominating convention where Phil Lyman and Natalie Clausen won 67% of the delegate vote. And then here's an article I put in there that came out on, you see that the convention happened on the 25th. And prior to that, this article came out that Governor candidate Phil Lyman calls for audit into the Spencer Cox signatures. In terms of the timeline for the campaign, I want you to keep your eye on this August 8th election deadline to challenge the ballots. That's in the law. And then we had the general election on the 5th of November. This article came out in July by the Salt Lake Tribune. I'm not a conspiracy theorist. Phil Lyman's long shot strategy to overturn Governor Cox's GOP primary win. I didn't put this on the timeline, but it's worth noting that at the beginning of March, the Lieutenant Governor had issued a press release claiming that she appointed former Lieutenant Governor Greg Bell to act as an ombudsman of sorts in the event that any election issue came up that dealt with her, since she was a candidate, that he would take care of it. All right, let's move over to the Lyman court case. And just to avoid confusion, there were several cases going on in court. This one is the Graham appeal in 3rd District Court to view Governor Cox's signature package. As I have explained in previous updates, during the April 27 GOP nominating convention, a mutual friend introduced me to a state delegate from Washington County who needed help obtaining State Senator Ibsen's signature list. So I submitted a grammar request for his signature list and initially received a response from the county clerk saying that I could come in and view the signature package. Then I received this letter on May 23rd from the district attorney saying that I could not see the package due to an ongoing criminal investigation. And by the way, under GRAMA, that's appropriate. That around the second week of June, I received a call from Natalie Clausen. She told me that she was a lieutenant governor candidate and that the response from the Washington County attorney was brought to the attention of the Lyman campaign because they were questioning the integrity of the governor's signature verification process. And it just so happened that the governor used the same company, Gather and Inc., that Senator Ibsen used. Natalie submitted a grammar request on June 10th to see Governor Cox's signature package. And that grammar request was denied. And by the way, she even in her request asked that Greg Bell, who was appointed to be an independent advisor, that he look at her grammar request, but that never happened. So instead, the lieutenant governor takes 2 weeks to respond to the grammar request, denies it. Then Natalie has to file an appeal to the lieutenant governor's office. The primary election happens, and she gets a denial of her appeal. And so the Lyman campaign bypassed the state records committee and filed an appeal in the 3rd District Court. I didn't put it on the timeline, but it's interesting to note that on the day that Phil Lyman files this grammar notice of appeal in 3rd District Court, Lieutenant Governor Henderson issues a statement to all county clerks regarding grammar requests for election returns, that they're not to give him out. I want you to keep your eye on this date, the July 17th. The Attorney General, on behalf of the Lieutenant Governor, represented to the court this position about the signature verification process that we'll come back to in the next segment. This case that Lyman filed in court was eventually dismissed on December 19th. Over on X, Natalie posted a summary or a report of the fact that the case got dismissed. And it's interesting that Todd Weiler, who's a state senator, if a candidate like Phil Lyman is utilizing a different branch of government to try to address some of his concerns, I don't understand the reason that a senator, sitting state senator in another branch of government, feels his need to taunt and mock. You know, that when Lyman, files a case, you got Senator Weiler mocking and taunting. And when it gets dismissed, the same thing. And he says that this loss, chalk up another loss for Lyman. I would chalk up Senator Weiler's reaction to just part of the playbook that the governor and lieutenant governor have been implementing some of their tactics. And you can pause this. I've gone over it in previous updates, but you can pause it if you want to look at this cycle that they go through, and they utilize these various tactics. Now let's overlay some of the events of this grammar request that I did. By the way, I think the lieutenant governor just said in a recent filing that I've done over 30 grammar requests with them over the last year on this issue. So this particular grammar request that I did during the first week of July, I was notified that by residents in Vineyard, Utah, that they were approached by this investigator, Jordan, and she came to their house and showed them a petition with Governor Cox's name on it and asked if they had signed it. They said no, and that their names were indeed forged. A number of their neighbors were too. So I went and visited with them. I got a copy of this business card that Agent Jordan left with several of them, and I submitted a grammar request for this AG 24-170. What I expected is that I would get a letter similar to this one, as you remember the one that I got in Washington County. I expected to get one on Attorney General letterhead, and it just said, we're not giving you the records, we're denying your request because there is currently a criminal investigation. I was going to give that letter to Natalie Clausen and say, hey, this might help you in your court case. Maybe your attorneys should show it to the judge that there is an issue with Governor Cox's candidate petitions. Instead, I get a letter from Lonnie Pearson, who was a records officer at the time, and he says, despite a reasonable search, the office found no records responsive to your request. So that was odd. That I know there's a case number, AG 24170, and he's saying it doesn't exist. And by the way, on the day that I get this letter from him, that's the same day that the certification of the primary occurred. But again, keep your eye on August 8th, the election deadline to challenge on the ballot, because in my opinion, this is all they were doing, is trying to run out the clock so that Phil Lyman couldn't challenge anything. If he got any evidence before August 8th, he could have challenged it, but they were determined to make sure he had nothing. So I ended up filing my grandma notice of appeal. And by the way, what I want to show here is just the position that the Attorney General was taking in the court on behalf of the Lieutenant Governor. But we'll come back to that. And so I filed my appeal, and Daniel Burton says that, and you see here, he knows what case number I'm looking for. He cites it, and he says, having researched this matter, I confirm that the office has no records of, so they don't, she's saying that even he's looked and there's no case number on this. So I filed my grandma notice of appeal. And this was the most bizarre part of this process for me at the time, was when the State Records Committee Executive Secretary, Rebecca Shaw, refused to schedule my appeal for a hearing before the State Records Committee. I should point out that I had my doubts about the accusations that Phil Lyman and Natalie Clausen were leveling against the governor, because I couldn't wrap my mind around the fact that a sitting lieutenant governor and governor would be acting corruptly in an election process. However, after receiving this denial letter from the State Records Committee Executive Secretary, it was a jaw-dropping moment for me. I realized that there may be some substance to these quote-unquote conspiracy theories. So I rearranged my schedule so that I could give this issue my full attention. I ended up making this video. You can go back and look at it. That gives you a lot more detail about what happened when I filed this grandma request and the responses that I received at the time. Going on to the next, let's get to the outline about the offense report. So what I've done is I pulled some of the pertinent dates from the offense report. And what we see here is that on April 6th, the Lieutenant Governor's office, Ryan Calley, actually contacted the owner of Gathering Inc. and told them that they had a number of their signatures from a particular signature gatherer that were forgeries. And we'll come back to that. On April 25th, Attorney General Special Agent Jordan is assigned case AG 24170 by her supervisor. Agent Jordan is given 48 candidate petitions purportedly submitted by one signature gatherer. On May 29th, Attorney General Agent Jordan meets with the Lieutenant Governor, State Elections Director Calley, and Elections Assistant Specialist Wade. Calley explained to Jordan the signature verification process followed by the Davis County Clerk. He says that when the Davis County Clerk suspected forgeries in Governor Cox's candidate petitions, the signature packets were removed from the verification process and sent to the Lieutenant Governor. Wade informed Jordan that he had already started the process to verify the signatures in the 48 signature packets. Jordan then gave him 48 petition packets back that she had received from her supervisor. And then she says on June 14th, Attorney General Special Agent Jordan says, once I get the circulator petitions back from the Office of the Lieutenant Governor election staff, I will conduct interviews with the verified forgery victims. Let me also point out here, well, I'll come back to that. So moving on July 1st, 2024, Attorney General Special Agent Node meets with the Lieutenant Governor Elections Assistant Specialist Wade. Wade verified the signatures in the 48 packets, determined that 2,146 of the signatures in those packets were forged, and that 84 of the signatures were valid. The 48 packets were given to Node, who took them back to the Attorney General's office and delivered them to Special Agent Jordan. And then here on July 3rd, Special Agent Jordan goes and interviews the victims that were on the Governor Cox's list. The rest of this I'm going to skip for now and go over it when we talk about the audits, because it kind of gets we'll lose our ability to understand what's going on here if we jump into this chronologically. So just keep in mind that we'll come back to these audits and actually we'll probably have to do a whole different update to them. But what I want you to understand for now is that, let me see here. There's one more document. Basically, this is just came out of a court case earlier this year. But what he's saying here is that Lonnie Pearson says in a meeting held July 16th that he went to the division chief, Leo Lucy, who informed him that there are no records responsive to the request because the Attorney General's office investigation involving signatures gathering was not related to Governor Cox. So let's go a little deeper into this court case and how I believe it was really the catalyst for a lot of their actions that they took during the summer of last year. So you see here that on July 1st, she gets back the signature package that the lieutenant governor verified, which is actually, this is the candidate. The lieutenant governor is the candidate. And she was able to verify signatures that were turned in for the governor. On the 17th of July is when they filed this petition in opposition to Lyman's motion for a restraining order. And the Attorney General represents to the court that the signatures on Governor Cox's list, that they were verified through the rigorous statutory process. And that not only that he actually submitted more that were needed, close to 600, that were unverified by election workers. The Attorney General goes on to tell the court that petitioners, meaning the Phil Lyman and Natalie Clausen, also suggest that Governor Cox submitted just barely enough signatures to qualify for the ballot, and he says that's false. Here, election officials had in their possession almost 600 additional signatures from Governor Cox that they did not check because they had already verified enough petition signatures to qualify Governor Cox for the ballot. So we already see here that that's a false statement, that he's actually making false statements to the court, because of those 600 additional signatures, 47 of them were verified by the lieutenant governor. We just saw that in the offerings report. And out of those 47% that were verified, only 15% of them were even valid. So he should have told that to the judge, but he doesn't. He lies to the judge by claiming that they were not verified, and that's not true. Half of them were. He goes on to tell the judge the lieutenant governor's office contracts with the Davis County clerk to verify signatures because the Davis County clerk's office, they want to avoid any conflicts of interest. That's a lie. We just saw in the offense report that they totally disregarded this conflict of interest, and that it wasn't the Davis County clerk that did the verification on those signatures. It was the lieutenant governor. Here, the Attorney General goes on to tell the court the Davis County staff processed petitions for 32 candidates. That's not true. The lieutenant governor processed them also. They says that the petitions were date stamped. That's not true. I have, through grammar requests, I have petitions that have no date stamped on them. He says all petitions remain in the custody of the Davis County clerk personnel throughout the verification process. That's not true. The earliest the verification process could end would be April 15. We know that they had these petitions probably in March. But according to this, at least, by April, 5th or 6th, they knew that the signatures were forged in 48 packets. Utah law requires a rigorous process for verifying candidate petition signatures. Each petition was processed through the following statutory steps. That's a lie. We know that 48 of them were not. I think there's more than that, but I'm just letting you know, let's just stick to what the record is that we have before us, that 48 of them didn't follow this process at all, because that would mean that the Davis County clerks would have verified the signatures in them, and that's not what happened. The lieutenant governor verified her own signatures. The attorney general goes on to tell the court if a signature is invalid, it is rejected and a reason for the rejection is recorded. Once Davis County personnel determined that a candidate had met the needed number of valid signatures to qualify for the ballot, the lieutenant governor's office was notified. That's probably not true because the lieutenant governor was verifying her own signatures. So now we see that's why the attorney general's office denied that the offense report even existed. Because if the court was aware that the Governor Cox signature packets were moving back and forth between the clerk, the candidate, and the attorney general before the signature verification process was done, in all likelihood, Judge Nelson would have ruled in favor of Lyman and compelled the lieutenant governor to allow him to view the signature package. So, classifying incriminating records as protected under GRAMA to cover up misdeeds is a standard operating procedure for the attorney general. But to say that the record doesn't exist, that's on another level. Nevertheless, we kind of get an idea why they wanted to hide that, because it would have jeopardized their standing with the judge. They would have jeopardized their case in the court, and Lyman would have prevailed, and they couldn't have that. So closing the ethical gap in an organization requires a thorough understanding of its top leaders' decisions and behaviors, which we see here. In the absence of a leader who believes in ethical decision-making, an organization won't behave ethically. And we see that here. This is, by the way, is a affidavit by Lonnie Pearson to the court in a different appeal that I had earlier this year before the court about these records, about the offense report. He said these records, however, do not exist, as the Attorney General's office never performed an investigation. And he said no investigation is taking place, yet Clara continues his pursuit. Clara cannot establish that the Attorney General office maintains records responsive to his request. Accordingly, Clara's petition should be dismissed. In Utah, we reward those who demonstrate their mastery of deceitfulness. And these guys take care of each other. That is how corrupt institutions like the Office of the Attorney General has perpetuated its culture of cloaking its activities in darkness, because it keeps these unethical people in the top levels of the Attorney General's office. Many of us refuse to play the part of always losing to these corrupt public officials. We want to win with the truth by exposing the corruption. We understand that the major feature of accountability is demanding the release of documents that the criminals in government arrogantly created detailing their malfeasance. That is why recently the governor appointed Lonnie Pearson from the Attorney General's office to replace the State Records Committee, and he's now, in essence, the administrative law judge for GRAMA appeals. But let me point this out here, that in 2023, this article titled Judge Blasts the Office of Attorney General Sean Reyes for Haphazard Record Keeping. And again, in 2023, this was a case between Paul Lyman and the Utah Attorney General. Paul Lyman is a former deputy attorney general, and he was seeking records from the Attorney General's office. And what the judge determined is he challenges their methods of getting records. He says the custodian, Lonnie Pearson, going hand in hand to various departments and asking them if they have relevant records. He said that's wrong. And that a 2015 legislative audit even said as much and gave the Attorney General's office funding to change that process. So, for example, if I go submit a GRAMA request to the Salt Lake Police Department for a particular case number, they just got to punch it in their database and boom, I get a copy of the report. That's all Lonnie Pearson had to do is punch it into whatever database they have, AG 24170, and he could have either provided me with a copy or said, yeah, we have it, but we're not giving it to you. Instead, this affidavit that he submitted to the court, he says about this offense report, in a meeting held July 16, 2024, former Investigations Division Chief Leo Lucy informed me there is no records responsive to the request. So again, this is what I call incompetence camouflaging corruption. Here's another issue that kind of similar, but it's with the Lieutenant Governor's office. And to me, it's even more insidious because what's happening here is that you have adults like Deidre teaching the craft of deception to the next generation. So here you have Brody Bailey back in December, who was they call him the chief administrative officer under Grandma. He's responding to one of my Grandma appeals. And basically, he's calling me out and saying, look, that because I'm pointing out to them, I said, look, the Attorney General's office has already said there is no investigation. And now in November, the Lieutenant Governor's office is withholding records because you're saying there is an investigation. And I'm telling them you can't have it both ways. And so here you have Brody telling me, let me provide a measure of clarification in relation to your request. It appears there may have simply been an issue of timing in relation to when you filed your Grandma request with the Attorney General's office versus when the packets in question were turned over to them. At the time of your request to the Attorney General's office, the packets had not yet been turned over for their review. The packets in question are now in their possession. So basically what he's saying is, look, when you submitted your Grandma request on July 8th, the Lieutenant Governor still had the packets. So that's why the Attorney General couldn't fulfill your Grandma request because he says, he's claiming they didn't have it. So that's a lie. We know that the Lieutenant Governor actually gave it to the Attorney General in April. And so this guy is just lying through his teeth. The problem is that here again in Utah, because of our culture, we reward people in government that lie. So he is actually no longer with the office of the Lieutenant Governor. He has now been promoted and works in the office of the Legislative Auditor General. And again, his unethical character is now transferred into the OLAG, which now I would question anything that comes out of their office if they're going to hire these kind of people that are not trustworthy and that have no problem with lying. So Utah is filled with public officials who breach their duty to uphold the law. They compromise essential principles and damage the public's trust. We have lost confidence in our government because we know they can't follow the law. As John Adams warned, it becomes a government of men who empower themselves to transgress the very rights and liberties we cherish. So in this audit, let's move on to the timeline in the audits. And I'm not going to go over them. I think we're going to have to, because of time, we're going to have to do another update just on the audits and how they relate to this offense report. And it's pretty deep. It's incredible. There's packets being moved around. It's the clerk, McKenzie, and the Attorney General actually hide packets from the auditor, the Legislative Auditor General. It's bizarre. But, so we'll have to go over that in the next update. And then we can go over why there's different numbers in each of the audits. This offense report actually gives us a little more clarity as to the line that was going on and why we have, it's just what I told you, that they had actually hid packets from the office of the Legislative Auditor General. But I do want to point this out. This audit number 3, we were not even aware that it was going on. And from the paperwork that I've seen up to date, and this may change if we get more information, but I believe that what was going on is that they were worried that Lyman might prevail in the appeal in the court case. and that the judge might rule in his favor and compel the lieutenant governor to show him the Governor Cox's signature package. And had he been able to see that, he would have seen that there were forgeries on it, meaning that he wouldn't have had to compare signatures to what's in the VISTA program. He would have just been able to see in package that they were all signed by the same person. We know that there were over 1,000 forged signatures like that the Davis County clerk, or maybe it was the lieutenant governor, determined they were valid. And that's how he was able to meet the threshold with over 1,000 signatures that we know are forged. And we know they're forged now because of this third audit that they kept from the public. And what we understand is that in mid-September, they started this audit number 3. And they did it by hiring 2 outside CPA firms. And they had about 14 or 16 CPAs that looked at every single signature. Understand, this was not a statistical review. This was looking at every single signature. And that's how they were able to determine the forgeries. And they go on to point out that the forgeries, they could just see them. They could just see on the page that they were all written by the same person. Yet, those are signatures that the Davis County clerk determined were valid and counted them towards Governor Cox. The only way we even know about this, again, let me point this out here. This actually started in mid-September, and it was done on December 3rd, I believe. And I heard another account, it might have been done in November, and they sat on it. And the reason is because as this court case is going on, you see, it doesn't get dismissed until December 19th. Had the judge, let's say on December 3rd, said, okay, Lieutenant Governor, you have to give Lyman the signature packets and let him look at them. Before that happened, they would have released the outcome of this audit. And they said, hey, we know that there are forged signatures in Governor Cox's packet. In fact, we know there's over 1,000 forged, and we also know that he doesn't have enough spare signatures to cover the backfall. But we know this already. We don't need Lyman to tell us. However, once Lyman lost the case and the judge dismissed it, they buried this. There was no need for anybody to know about it. The only way we do know about it is because Tina Cannon, who was elected and replaced John Dougal, luckily, she's the one that exposed it. And my understanding is that it was the co-chairs of the Government Operations Committee that asked her to come do a presentation on audit number 3, that there were whispers about that it was out there. So again, the legislature and a new auditor, thank you for shining light on the truth and letting us know what happened. Finally, let's talk about the legislature a little more. What I'm showing here in this graph is that back in July 18th, when Natalie Clausen was questioning, we're actually at the State Records Committee. This was for Senator Ibsen's signature list. And Natalie's listing all the things that are wrong with the current process and trying to persuade the State Records Committee to order the release of Ibsen's signature list to kind of counter the deficiencies in the process of signature verification in terms of having the public understanding the process for being able to monitor its progress. And so what ends up happening is a list of those things that she shared with the State Records Committee end up in October as recommendations with OLAG to the legislature. The legislature actually converts those recommendations into law, several of them, and we're still fighting for some others. But anyways, again, it's the state legislature, that branch of government, in my opinion, is to be commended because they came through. And all the people that are sitting here that support transparency, I want to commend you guys too for keeping on this issue and persuading your legislators to move forward with election reform on this. Earlier this year, me and Natalie Clausen actually did a presentation to the Rules Review and General Oversight Committee, and about some more improvements that need to be implemented through state law. What I want to bring up, though, is that at this hearing, you have State Elections Director Ryan Calley, and he says the Lieutenant Governor's office contract with the Davis County Clerk to perform this one thing. It does so to create that independence, so that the Lieutenant Governor isn't verifying packets in a race where she is potentially a candidate or running mate. The clerks do signature verification all the time. The Lieutenant Governor's office doesn't. See, that's a false statement, right? It mirrors a false statement that the Attorney General gave to the court. And here you have Calley saying the same thing to the legislature. And we know through the offense report that's a lie. Senator McKay says, you mentioned that in that process, he's asking Brian McKenzie, who's the Davis County Clerk. He says, Brian, you mentioned that in that process, when there are statewide races, when there is a concern about signatures, you forward them to the Lieutenant Governor's office. But that would include elections that the Lieutenant Governor might be involved in, right? McKenzie says, currently, yes. Then Senator McKay asked Ryan Calley, Ryan, how do you guys deal with that? When the county clerk sends things, incidences of fraud in the signature process, how do you guys deal with that? And then Ryan says, the way we dealt with it this past year, we just did a preliminary review. We do have about 75 years of election experience in the LG's office, which is kind of a newer trend, which that's just the most ridiculous thing. I have no idea. I mean, he's just an idiot. So that has no bearing on anything, but that's just part of his smokescreen. He goes on and he says, we just review the packets that the clerk gave us. Actually, all of those were referred over to the AG's office for investigation. What he doesn't tell Senator McKay is that they had already started, and I say they, the Lieutenant Governor had already started verifying those signatures in those packets, gave them to the Attorney General. He did refer them to the Attorney General. The Attorney General gave them back to the Lieutenant Governor to verify them officially, which is not their role, which is not what the Attorney General told the courts. It's not what, now we have the Lieutenant Governor. That's not what they're telling the senators. But again, it's part of their lies. And because they don't want anyone to know the truth, because they didn't think that we would ever see this offense report. Nobody even asked McKenzie anything about this, and he's going to bring it up again. He says, Mr. Chair, if I may provide some clarification, just some additional information of those packets that are forwarded, it is important to note that the Lieutenant Governor's office did not take on the role to verify those signatures. That remained under our responsibility. All right, so somebody's lying. Do we think that Agent Jordan is lying? Or do we think that Brian McKenzie is lying and Ryan Calley's lying? My money's on that these two clowns are the ones that are the liars. But again, it's okay. Everybody can lie. That's the Utah way, that we have attorneys that can lie to the judge. We have election officials that can lie to the legislature, and nothing happens to them. And let me just say, side note here, I have a grandma appeal coming up next Friday, and actually not next, in 4 days. And so in that, the Attorney General's office had to submit some paperwork to the records officer, who's Lonnie Pearson, and he just reiterates. He says, at the time of review by the Davis County Clerk's office, signature packets from certain petition circulators were flagged and pulled under suspicion that those packets bore fraudulent signatures. The clerk sent those packets unreviewed, unverified, to the office of the Lieutenant Governor. So he's contradicting what Calley and McKenzie just told the legislature a few months ago. So take that for what it's worth. Let me also point out it's illegal to lie since May 1st of 2024. It's illegal to lie to the committee, a legislative committee. Nevertheless, our reluctance to recognize the importance of what I call administrative evil as part of the identity and practice of public policy and administration reinforces its continued influence and increases the possibility of future acts of deception and destruction if we don't address it. And we don't address it. That's just, again, the Utah way that it's all performative. That these guys, everybody can just lie to officials in the various branches of government, and there's never any consequences to it. So I don't expect anything to change if we're going to if it's all just theater. At the end of the day, I would say that this story is about hubris. Sure, there is collusion, there's a plot, there's a cover-up, but hubris is a more fitting word. This is a story about what happens when those we trust to be the guardians of our electoral process have instead usurped our capacity for self-determination.